I'd like to call the May 15th Board of Adjustment meeting to order. Hearings before the Board of Adjustment are quasi-judicial in nature. Decisions of the board are based on the record of these proceedings. To grant a variance requires a concurrent vote of 4/5 of the members of the board. To reverse or modify the determination of an administrative official requires a simple majority. Evidence submitted to the board for review becomes part of the record. Appeals to board decisions are to Superior Court and are based on the record. Appeals must be filed within 30 days of the date of filing of the board's order in the Planning Division. A hearing before the board is conducted in accordance with its rules of procedure. Those who want to testify in a case are sworn as witnesses. The chairperson recognizes those who want to testify or their attorneys for presentation of evidence during the hearing. To ensure that all testimony is properly recorded, please come forward to address the board, state your name and address, and speak clearly. Go ahead and swear in the witnesses.
All right, I'm going to ask that staff, applicants, and members of the public who wish to speak today, if you'll stand and raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. The first order of business is approval of the minutes. Do we have a motion to approve the minutes from April 17?
So moved.
Do we have a second? All in favor?
Aye.
Aye.
Motion carries. We also have approval of minutes from the April 24 special meeting.
So moved.
Do we have a second?
Second.
All in favor?
Aye.
Motion carries. We're waiting on another board member that should be here any minute, but in the interim, we're going to address item 4, which is 5302 Autumn Drive. Applicant has requested a continuance to the June 12 meeting date.
Make a motion to continue item number 4 to the June 12th meeting.
We have a motion. Do we have a second?
Second.
All in favor?
Aye.
Aye. 5302 Autumn Drive is continued to the June 12 meeting. And before we get to our new business, we're going to need to wait a couple minutes for our missing board member. Thanks. I'd like to reconvene the May 15 Board of Adjustment meeting. Our first item on the agenda is 154 Parkwood Drive, variance to City Code Section 18-199, accessory structure setbacks to allow a detached accessory structure to remain as permitted.
Good afternoon, Mr. Chairman, members of the board. I'm Grace LeMay, Zoning Planner 1 for the City of Wilmington. For item 1 today, the subject property is approximately 19,999 square feet, zoned R15, and contains a single-family dwelling. On or about November 27th, 2025, the applicant received permitting approval from both City Zoning and New Hanover County Building Safety for the construction of a detached 11 by 30 lean-to carport with a proposed 3-foot setback to the side interior property line. In February of 2025, City Zoning inspected the subject property and determined that the structure did not comply with City Code Section 18-199, which requires that detached accessory structures shall be located a minimum of 5 feet from side interior property lines. On or about February 26, 2025, City staff accepted an application for a variance to the required side interior setback for the accessory structure to remain as permitted. When the need for a variance is related to an error on the part of City staff, the City of Wilmington fee schedule states that no application fee is required. This matter was continued from the March 20th meeting and is set for hearing before the Board of Adjustment on May 15th, 2025. I'd like to submit the staff report and all attachments to the record. I'm available for any questions, as well as the applicant's representative, and I believe they have a presentation as well.
Any questions for staff? Okay, thank you. If the applicant would come forward.
Good afternoon, Board. My name is Dakota Lipscomb. I'm an attorney here in town representing the applicant Cobra Lane for the variance request for 154 Parkwood Drive. This is a request for the city to grant a variance for a now complete carport that is within the 5-foot setback to the adjacent property, the 5-foot side interior setback. This is a picture of the now complete carport. The one to the left is from the street side. The one to the right is facing the street. And you'll see this aerial depiction of the property. I'd like to note for the board that the driveway, which pre-existed the carport, has already been there for several years and is very close to the property line. And I'll also point out in this other aerial, there are 2 houses adjacent to Mr. Lane's property. One is a property with a driveway that's on the far end, the far left of Mr. Lane's property, and another is a corner lot which has not 1 but 2 driveways connecting to a separate street, Mockingbird Lane. This is a bit more of a technical view of the carport that Mr. Lane built. Mr. Lane is 75 years old. This was a personal project that he commenced. He placed the 220-pound columns with the help of a friend for this carport, built the rafters, got the footings in place, and you'll see here the depiction of where it is now, the 3 feet and 3 inches separating it from the property line, the 11 feet by 30-foot square footage or surface area that the carport takes up. And I'll also point out the rear door steps to the house, which are adjacent to the carport and are 4 feet separating both the carport and the house. So if the carport were to be moved any closer to the house to comply with that 5-foot setback, those stairs would be blocking a car to enter the carport. Now, this permit was granted due to, what I think is a very understandable issue. If you go onto the county's website, and there is a link on the city's website that will eventually take you to this page, you'll see there is an option for accessory new structures. And this is the page called Do I Need a Permit? So Mr. Lane, before he even commenced building this carport, was trying to figure out the rules. He looked at this site, and then he selected carport. And there, in his layperson's opinion, and in my opinion as an attorney as well, he saw this greater than 400 square feet requirement. Now, what we saw a moment ago was a carport that was 330 square feet. So in Mr. Lane's mind, he didn't need a permit to proceed with building the carport. In addition to this, he also called a member of the county, spoke with them on the phone, and confirmed that he did not need a permit as long as he didn't have any electrical or plumbing improvements to the carport. This is a picture of the carport under construction for what turned out to be the second time. Mr. Lane proceeded with building his carport 2 feet away from the property line. Again, he did not think he needed a permit to proceed. It was after he got the columns in place and the rafters built that a representative of the city came out and told him he needed to comply with a setback requirement of 3 feet. And a little bit more context, this interpretation, I think, was due to another misunderstanding, but a legitimate one of the rules that exist, particularly at the time when he was building this late last year. So this, what you see in front of you, is a selection from the North Carolina State Building Code. You'll note that it is about fire safety and the minimum distance between structures, including accessory structures like a carport, for 3 feet. It does allow, if you look in, I think it's item number 4, you can potentially get as close as 2 feet to a lot line. And again, this is all from the perspective of what would be safe and to reduce fire hazards. Mr. Lane was informed that if he coated the carport with special fire-resistant paint or made a 1-hour proof wall, he could potentially keep his carport where it was. Due to cost considerations and other considerations, he ultimately decided to dig up the carport and then move it over a foot to comply with the directions from the city. So this is another section from the LDC which it turns out the city has interpreted to not apply, discussing a side interior setback, specifically an encroachment for certain devices like shading, porches, and other kind of accessory type buildings near a house. This mentions 3 feet, this mentions 2 feet, and the reason why I'm bringing this particular part of the code up is because Mr. Lane, when he discussed with the city and eventually went to the planning office himself to try to figure out what he had to do to build his carport, he got this note. That note discusses what I see as a 3-foot setback, and then 3 feet of encroachment no closer than 2 feet to the side of property line. So essentially, Mr. Lane did everything he could to try to make sure his carport, before he was building it and while he was building it, and then once he got additional information from both the county and the city, to do everything that I think this board would like its citizens to do when kind of doing these home improvement projects. In February of this year, Mr. Lane had completed the structure. The county came by and visited the property. They determined that it was in compliance with their rules and passed the carport as built. That same day, the city inspected the area and determined that, in fact, a 5-foot setback for the side interior from Section 18199 applied to the carport. The city was kind enough to waive Mr. Lane's application fee for this variance, and that brings us to where we are today. It's my understanding that the board is familiar with these requirements, so I'll go through them pretty briefly. 1, unnecessary hardship would result from the strict application of this chapter. 2, the hardship results from conditions that are peculiar to the property. 3, the hardship did not result from actions taken by the applicant or the property owner. And 4, the requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice is achieved. To this first point of unnecessary hardship, Mr. Lane did everything he could to follow the directions he got online, in person, on phone calls, and at the city's office to make sure he was building his carport in accordance with the rules. After he found out halfway through the project his setback was inappropriate, he dug up those columns, he disassembled the carport, and rebuilt it a foot over. And again, what we're talking about here, and that was depicted in that graph we were looking at earlier, is 1 foot and 9 inches away from what we're supposed to be at. This is another image of the carport under construction, and we've highlighted the staircase that makes it impractical to move the carport further into Mr. Lane's property. And that precisely leads in this second point of hardship resulting from conditions that are peculiar to the property. The fact that Mr. Lane built his carport, and according to the permit, and it is now a part of the property itself, constitutes a condition on this property, in addition to the other factors we were talking about earlier, the other lots, the topography, and the unique situation of this situation. For the third point, none of the hardships resulted from actions taken by the applicant or property owner. Mr. Lane worked hard to get this carport done the right way, and due to an understandable set of circumstances, it is now determined to be not in compliance with the LDC. This is the carport again, and you'll note that space is 15 feet away from the adjacent property. You'll see that there is a fence providing some privacy between the carport and the next door lot, and that leads into this fourth and final point, which concerns public safety. Not only do I think would substantial justice be achieved by allowing this carport to remain and not requesting my client take it down for the second time, thinking back to that state building code for residential properties, there is no fire safety risk with this carport. That was concerning 3 feet between structures. There's a 15-foot gap between our carport and the adjacent house, as well as 4 feet separating the carport from Mr. Lane's own house. This is a factual timeline of the carport and its construction. I've highlighted in yellow the varying instructions that Mr. Lane either saw or received during the course of this project. And that concludes my initial presentation, but if the board has any questions, I'm very much happy to answer them.
Thank you. Any questions for the applicant? Okay, thank you. We'll now open the evidentiary hearing. If there's anyone that would like to present evidence that's pertinent to the case, please approach.
Hello, my name's Terry Parham. I live at 160 Parkwood Drive. I am Mr. Lane's neighbor, next door neighbor. My property basically is where his lean-to has been built. I have pictures that I'd like to present to you. I really don't know how this works. I believe that when Mr. Lane first approached me in September that he was going to build a carport that was going to improve his property value, I assumed he was going to build a carport that was attached to his home. It's not. It is a lean-to. The house, which when I moved in '85, the original owners were still there. The house had a carport, and Mr. Lane enclosed that carport to make, for living purposes, at what point he did not receive a permit to build. And then he also did another project on his property, putting in an apartment and a woodshed that didn't receive a permit. So I became concerned when I saw how close the structure was going to be to my property and started calling the city asking, did he need a permit? At which point, he told me he did not, but the city came and stopped him, and this has been an ongoing process. My concern is, first of all, I really had no problem with Mr. Lane putting a carport in. This is not what I expected him to build. My concern is flooding on my property. The map that shows Parkwood Drive starting at Longleaf Hill shows that the road continuously goes down to Mockingbird. It's just a slope all the way down. You can see that in these pictures also. It was mentioned that he started this project and then moved it. I never saw any evidence of that. I know he started it and stopped it, and then started it again and finished it. I don't really want to cause him problems, and I don't want him to have to go to the expense, and maybe it shouldn't be taken down. But I'm really concerned about flooding in our area. I don't know who made the mistake. It appeared to me, not knowing anything, from the get-go it was too close to my property. So if I could just leave these pictures with you and you take a look at them.
If you'd take them as evidence. Thank you.
So thank you for your time.
Okay, any questions? Okay, thank you. Mr. Lipscomb, would you like to cross-examine? Yes. Mr. Lipscomb, photos are available.
Hello, Ms. Mayor. Oh, that's loud.
Hello.
I realize you probably didn't expect to be asked questions by an attorney today, so I'll try to keep my questions brief, if that's all right. Okay. So it sounds like flooding is your primary concern with this new addition.
It is.
Okay. Do you currently have any water issues at your house?
Not to my knowledge.
Okay. I
And
noted
when you say issues, is there something specific I should be thinking about?
flooding, water intrusion. Do you have anything like that?
Only at the bottom right now of Mockingbird and Parkwood.
Okay. So the street opposite of where my client's property is.
The street opposite. Well, Parkwood and Mockingbird, so yeah, well, the way it comes down, so it's coming down the street, down Longleaf Hills Drive, past his house, towards my house to Mockingbird, if that makes any sense to you.
Yeah, if you wouldn't mind pointing that out.
Yeah, so I'm assuming Longleaf Hills Drive is up here. Yeah. So so it's high here at the top, and it just comes down. The land just slopes down. I would guess where his driveway is, it's probably this much higher than my property. I don't know, 2, 3, and 4 inches, I don't know.
And then it just keeps flowing down to the street corner.
Flowing, yes.
Okay. And do you have gutters at your house?
Yes.
Okay. You've gave us one of these pictures here. Can you point to where those gutters are?
My gutters are on the back of my house.
On the back of your house?
Yeah, on the back property.
Okay. And do you have an opinion of an expert to support
Oh, no,
any of? Okay.
no.
And just to make sure we get it for the record, do you have any expert evidence or expert opinions that the carport will pour water onto your property?
No.
Okay.
I would like to say one thing. When he did say he was going to build this carport, I honestly pictured the roof line, because he said it was going to improve his property value. I assumed the roof line to the carport was going to match his roof line to where it would go front to back, like all the other houses in my house, instead of this lean-to going straight towards my house.
Okay. Well, those are all my questions. Thank you very much.
Thank you.
And if I could have a moment to,
Yeah, we'll have time for closing. Yeah.
thank you.
Okay, we'll move to closing statements. Mr. Lipscomb.
I think it's understandable in this area for Ms. Parham to have concerns about the possibility of water intrusion at her property. The facts and best available evidence to the board, I think, however, demonstrate that the carport itself would not be the cause of any issues that might potentially lead to water intrusion on Ms. Parham's property. And I'd specifically like to note a couple things in these pictures for the board's review. First, you'll see that the soil around the property is pretty sandy. And then you'll note that there is a gutter system that my client voluntarily installed on his carport. That gutter system goes to a downspout with 7-inch pipes that then point away from Ms. Parham's property. In addition to that, Mr. Lane has constructed a silt fence going 6 inches into the ground. And I would also like to add that my client is, before his retirement, was a construction engineer for the Westfield Corporation, as well as a senior construction manager for Parsons, and is of the opinion, based on his observations, even in the last week, I know we've gotten a lot of rain, that there is no water issues arising from the carport. And more importantly, I think, and this is a point we discussed earlier, there's a 15-foot separation between Mr. Lane's carport and Ms. Parham's house. And if you look at least the front of Ms. Parham's house, any water issues, let me rephrase, the carport gutter system would well take care of what you might expect from rain coming down onto the roof of the carport. And if the board has any additional questions, I'd be happy to address them.
Thank you. Any questions from Mr. Lipscomb? Okay, thank you. Ms. Palmer, do you have anything further to add?
I'm interested in what he said, that the fence goes, I don't understand what you mean when you said the fence goes 6 inches down into the ground. What do you mean by that?
You can approach, yes.
I was referring to a 6-inch silt fence. My client understands the details a little bit better than I do. It was my understanding that it was designed to prevent water damage. As far as where it goes, I don't have that information.
Yeah, well, I can tell you that that doesn't make a lot of sense. I mean, I can understand where the posts that he put up to support the panels that were prefabbed panels may be sunk that far, but the actual fence is not. And I, don't get me wrong, I don't expect y'all to make him tear this down, and I honestly don't want him to tear it down. I don't want to cause that problem with my neighbor. But somebody made a mistake. I don't know, city, county, whoever. And this really needs to be corrected, because the next person that's in my situation shouldn't have to go through this. I can't tell you how much stress this has caused me since September, thinking about the possibilities of the cost that it's going to occur to me down the road somehow. But anyway, thank you. Thank you.
Thank you. Yes, yes.
Forgive me. This is sort of a question for both of you, because I had noticed the downspouts and the, shall we say, the tubes, the drains. The gentleman for the applicant indicated that the water doesn't go towards your property, ma'am. On the other hand, we've had a lot of rain. So two questions, one for you, ma'am, and then perhaps one for him. For him, it's, so then where does this water go, if you know? And then for you, ma'am, considering that we've had a lot of rain, have you seen evidence of this system failing to keep the water from flowing towards your property? I know your property's a little bit downhill. We noticed that, but
Well,
thank you.
actually, I went out yesterday when we had the big rain. And with that, it was fine. I have no problem with that, with the way it was. I guess my concern, I just don't know when the next hurricane's going to come. And we're, of course we don't. And that type of flooding. The rain storms that we have, which are usually quick, they could be very intense, but quick. But he's correct. We do have sand and it does drain. And as far as those black pipes or whatever they are that are coming out, I really hadn't noticed those. I'm not sure, because I was told, because I don't go onto his property, that there were going to be rain barrels. So I'm not sure where the rain barrels are opposed to this black tubing that I'm seeing.
Thank you.
So to kind of add on to that, I was in communication with my client, and he informed me that I think it's the roof gutters drain into 4-inch plastic corrugate piping to the center of Mr. Lane's yard. That is not just moving it further down the property line. It goes to the center of the yard. And I would also, and I think the board may have used this tactic in the past, where it can attach certain conditions if any particular aspect of a variance is something that they think deserves a little bit more caution. And again, as a thank you to Ms. Parham, I think she mentioned earlier the right result might not be to make my client take down the carport again. Again, Mr. Lane attempted to do everything right. He went through the permitting process. He called people. He made adjustments, and we find ourselves here today. And we are grateful for the city for waiving the application fee in addition to giving us this opportunity to try to make this situation right.
Thank you. Anything further from Mr. Lipscomb? Thank you. Anything from the city?
I would just like to note that based on the topography of that site, the water would actually drain towards the property to the south of 154 Parkwood towards Hewlett's Creek rather than the neighbor's property.
Okay, thank you. Okay, we'll close the evidentiary hearing and open for a board discussion. A couple of things that I'd like to say is, Ms. Parham, I understand your flooding concerns, but in the absence of an expert witness that can validate your flooding concerns, I really don't think they're pertinent here. And I do think that Mr. Lane has really gone above and beyond. It's an unfortunate situation, but it was a permitted improvement, and it was built per the permitting process, and he followed all the rules and went above and beyond a little bit. So that's my 2 cents.
I would agree with that. I think the hardship really comes from, unfortunately, a mistake on the city's end with the permitting process, and so I'd like to make a motion to approve this.
We have a motion to approve the variance as requested based on the 4 findings of fact. Do we have a second?
I'll second.
All in favor? Aye.
Aye.
Anyone opposed? Passes 5-0. Thank you. The second item before the board today is 420 Evans Street Variance to City Code Section 18-28 setback requirements for a new residential structure in the R5 district.
This item was continued from the April 17th meeting. The applicant was not present for that continuance, and the applicant is not present today. I'm happy to proceed and present the request to you all if you'd like for me to.
Yes, please.
The subject property at 420 Evans Street is zoned R5 and is a vacant lot of record in the R5 district. That district requires that newly created lots contain at least 5,000 square feet and have a minimum of 50 feet of width. The subject property, though, is a lot of record in the Fox subdivision, and it's made up of 2 lots. This is recorded in New Hanover County Registry, Map Book 2, page 108, and you can see that lightly on your screen. It's from 1926. Lots within that section of the Fox subdivision are generally 33 feet wide and 92 feet deep, which is consistent with the dimensions of the subject lot. The applicants proposed to develop the property for a residential use and has requested a variance to allow the new structure to meet a 5-foot side yard setback rather than the 7-foot setback as required by City Code Section 1828. The subject lot is 17 feet narrower than the standard R5 lot width of 50 feet, and you can see the required dimensional standards for the R5 district. The applicant stated in his application that strict enforcement of the ordinance would significantly constrain his ability to develop this lot. And you can see, based on the lot dimensions, it's really more consistent with the standards for an R3 district And those are the setbacks that he's requested to have on the side yard. In the applicant's narrative, he also stated that the proposed use would be a duplex. However, the lot is not large enough to accommodate a duplex in the R5 district. He would need to have at least 7,000 square feet, so this would be for side yard setbacks for a single-family dwelling. This matter was set for hearing at the April 17th meeting and is before you today on May 15th, 2025. I'd like to enter the case summary and all attachments into the record, and I'm happy to answer any questions that you may have of city staff.
Ms. Thurston, so this is for a duplex, which would not be allowed even if a variance were to be passed.
He
Is
did
this
not
something that we
request
should-
a variance to the dimensional standards for a duplex, so no, the lot is not large enough to accommodate a duplex. He requested a variance to the side yard setbacks, so it would be for a single-family dwelling.
Okay, thank you.
This would remain R5, is not a rezoning to
It would
R3?
not change the zoning of the property, it would just apply the setbacks, the side yard setbacks that are consistent with the R3 zoning.
Okay.
He did not request a variance to the front or the rear setbacks.
If I may. So if I understand you correctly, the minimum size for a dwelling in an area zoned R5 is 5,000 square feet. Is that correct?
That's the minimum lot area
Oh, the
for the
minimum.
district. There isn't really a minimum dwelling size.
Oh, I see. So it doesn't, a certain width is not required. I thought the 14 or 15
In the
feet was-
R5 district, new lots are required to have at least 50 feet of width.
I see.
In the R3 district, they're required to have 33 feet, which is what this lot has. And with that's 17 feet less than what would be in a normal R5. So he's asking to apply the side yard setback standards that would be consistent with the actual lot width of his property.
And this lot is consistent with other lots in the area?
It is. This is one of many Fox subdivisions. You can see blocks 11 and 12. That's because there are Fox subdivisions, block 9, 8, 7, just all in that area. Some of them do meet the 50-foot lot width, but many of them were developed as 33-foot wide lots.
Thank you.
Why do we automatically assume that it's a single-family dwelling since he asked for a duplex?
Because that is all that he's allowed to build there based on the lot area.
But he hasn't actually changed his request.
No, he's not. He's not present to address that either.
So if we approve the variance, the only thing that would be allowed based on the variance would be a single-family dwelling?
There's a picture that came with this material that shows the lot that's, I don't know how to describe it. The one to the right of his in this picture is also a 33-foot lot that has a structure on it. But I obviously can't tell from looking at the picture if there was ever a variance issued for that particular structure.
Many of those lots out there, so the black lines that you see are parcel lines.
Right.
And those aren't necessarily the lot lines. So the lot directly to the south is actually a double lot. They built in the middle of those two lots, and so they kind of effectively combined them. But those are really two lots of record. Because they were developed in that manner, the tax department issued a single parcel ID number rather than two separate tax bills. But very few of the lots in this subdivision have actually been formally recombined. So most of them are still 33 feet in width.
Assuming north is the top of this picture, I'm talking about the lot to the east.
The dwelling on Clay Street?
That is a 33-foot wide lot, yes, sir. And the parcel lines, this is our GIS system, so it's several different layers. We have the aerial layer, we've got the parcel layer, the street layer. They get a little bit skewed, so that's not necessarily an accurate representation of where the property line is.
Okay.
Forgive me if I may, just probably more for my edification. If back in 1926 or so, so many of these parcels were basically, shall I say, designed to be 33 feet wide. How did it come about that this area, if I'm not mistaken, got zoned R5 when they seem to be more naturally R3 type
I don't
lots?
know, because I wasn't around at that time, but my suspicion would be the R3 district was also known as the Center City District, and this is, especially at that time, this was more suburban. So this was outside of what would have been the urban core, where you have the standard 33-foot wide lots.
Thank you for the context.
Any further questions for staff? Thank you. Oh, we do have a question.
Has there been any opposition from the neighbors?
We, city staff recognized last year that many of these lots were 33 feet wide and they're non-conforming. And so we as a city staff had a community meeting to discuss proactively rezoning this property to R3. Many neighbors came out in opposition to that proactive rezoning for various reasons. But no one has contacted me about this specific request.
Thanks.
Not even the applicant, since the application was submitted.
Thank you. Okay, thank you.
Thank you.
Since the applicant's not here, we'll go straight to the evidentiary hearing. We'll now open the evidentiary hearing to the public. If anyone is here to provide competent material and substantive evidence relevant to this matter, please come forward. Seeing no one, we'll close the evidentiary hearing and open for deliberations.
Well, I guess my question for you all, and maybe this is too broad, is, all right, so if the community for the moment is, shall we say, generally opposed to rezoning to R3, which would seem to be, allow more of these lots, unless I'm very much mistaken, to be more conforming, right? Because they'd be in the R3 bucket rather than the R5 bucket. Well, I guess the question would be, how do my fellow board members feel about the possibility then that we would have to be dealing with one sort of non-conforming application after the other, should other people seek to follow suit?
Well, I mean, it
Thank
could happen, but it's also, there's some infill. A lot of those lots have already been built on and have been built off for some time. So this is really a vacant lot in an area for infill, for a new dwelling to be built. I know the applicant wants to, or mentioned in his presentation, they wanted to do a duplex, but that's not possible. If we approve the variance, it would be for single family only, which does kind of conform with the neighborhood. We really have to view the variance request in light of the four findings of fact. You know, if you look at the four findings of fact, unnecessary hardship would result in strict application of the ordinance, which it would because the lot is smaller than R5 will allow. The hardship results from conditions that are peculiar to the property, which 33-foot wide lot would certainly be. The hardship did not result in actions taken by the applicant. Well, it was platted in 1928, so. And the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety, security, and substantial justice is achieved. And I don't think the proposal for a single-family dwelling, which could be put there, is really out of character with the neighborhood.
I would agree with that as well. Yeah.
So technical question again. So if we approve this variance, it would be with the, would it be technically a condition that it only be a single-family dwelling, since, as
Well, that's all
the
he can put
gentleman
there.
said, for the moment, it seems to be, the aim would have been to create a duplex?
Well, regardless of what he would like, the only thing that could be put there is a single-family dwelling. So if he goes and says, I want to put a duplex, they'll say, you can put a single family, but you cannot put a duplex. So we're not opening the door for multifamily.
He does not have the lot size for a duplex, no, the square footage. I'd make a motion to approve this variance as requested.
We have a motion to approve the variance as requested based on the 4 findings of fact. Do we have a second?
I'd like to second it.
All in favor? Aye.
Aye.
Anyone opposed? Variance requests passes 5-0. Last item before us today is item number 3, 1601 South 13th Street. Variance to tree preservation standards for the removal of a specimen trees located within the MD-17 zoning district as per City Code Chapter 18, Section 18-316.
All right, good afternoon, Mr. Chairman, members of the board. I'm Grace again, Zoning Planner 1 for the City of Wilmington. Item 3 today, we have the subject property, 1601 South 13th Street. It's zoned high-density multiple dwelling, residential, and that's the MD-17 district. It contains a multifamily housing development known as the Houston Moore Apartments currently. On or about April 22nd, 2025, a redevelopment plan for the demolition of all existing structures and new construction of 2 buildings with a total of 200 units was submitted for preliminary review by the city's Technical Review Committee. The proposed new construction would occur in 2 phases and would involve the removal of up to 3 specimen trees. Pursuant to Table 18-316-1 of the Land Development Code, any live oak with a minimum diameter breast height of 24 inches shall be classified as a specimen tree. Land Development Code Section 18-316B states that protected trees existing on a site prior to development or redevelopment that meet the size threshold prescribed in this table shall be retained. This section further states that removal of specimen trees shall only be authorized by the variance from the Board of Adjustment. Section 18-316D states that disturbance within the critical root zone shall not exceed 20% of the critical root zone protection area or extend any closer than 1.25 feet for every inch in trunk diameter. According to the applicant, the property contains 9 specimen trees that would be impacted by the proposed plan of development, proposing either removal or impacts to the critical root zones with the intent to retain viability of the trees. The applicant has requested a variance to Land Development Code Section 18-316 to remove or impact the critical root zone of the 9 specimen trees in the following ways. 1 38-inch live oak tree to be removed, and 2 live oak, 38-inch and a 33-inch, and the proposed critical root zone impacts are as shown, and they will be removed or, if possible, to save the trees to decrease the critical root zone impact. And then for the remaining 6 specimen trees, the current impact versus the proposed impact would be reduced as shown on the screen. The applicant states that the location of existing specimen trees with the building envelope significantly constrains redevelopment efforts. The trees were integrated into the original site design for the existing multifamily development and have grown so much since then that the applicant believes their location, combined with the existing site conditions, creates a substantial design challenge for the proposed redevelopment project. On or about April 1st, 2025, staff accepted an application for a variance to the tree preservation standards for a property in the MD-17 district pursuant to Land Development Code Section 18-316. On or about April 9th, 2025, the applicant met with staff to provide an updated site plan which reduced the impact of the proposed redevelopment plans to the critical root zones of the specimen trees. This matter is set for hearing before the Board of Adjustment on May 15th, 2025, and I'd like to submit the staff report and all attachments to the record. I'm available to answer any questions from the board, and the applicant is here as well with a presentation.
I do have one question regarding the 6 trees with disturbance in the critical root zone. Since the amount of disturbance is decreasing, is a variance necessary for those 6 trees?
No. If the impact is decreasing, they do not need a variance for
Right,
that.
so really, just to kind of pare it down a little bit, what we really need to address is the 3 specimen trees to be removed and not the 6 specimen trees with critical root zone.
Exactly. So it's going to be the 1 38-inch live oak that will be removed, or that is the request. And then the 2 additional trees, the intent is to save them. So, but it could end up being that they might need to be removed. So the request is either to remove them, or otherwise they will have a decreased impact to the critical root zone areas.
Okay, thank you. Yes.
First of all, thank you for that question to help clarify. And I also want to thank the staff, because if I read the materials correctly, it sounds like you all and the applicant worked to make some adjustments to then save those 6 trees.
Yes, there were some adjustments that were made to the original application so that there was going to be a decrease in the critical root zone impact to more of the trees, which resulted in they had to remove the portion of their application where they would be increasing impact to those critical root zone areas.
Okay, and I was concerned about sort of 2 other things. One is, so when I read the materials, it wasn't clear to me, and I think you've just reiterated this, but maybe the applicant will also address this. So why do we not know at this stage whether at least 1 or 2 of the 3 trees could still be saved? It sounds like there's maybe, we're not sure, because I noticed they wrote it as up to 8 trees. Fascinating way of phrasing it, but then if you look at the materials carefully, of course, 2 of them are still sort of...
Right, I think it is going to ultimately depend on the construction and the trees, so I would leave that up to the experts. I'm sure the applicants might have some additional information, and then our arborist might be able to speak more to that, but they are not present here today.
And one other thing which might seem to be on, I noticed there are other little circles sort of around the property. Are those indicative that they're going to be putting other trees and all that? I just asked that because in the picture of the original, well, what will be redeveloped, it's other than some of these species trees which have grown, it looks pretty denuded, frankly. Is the applicant going to be, to our knowledge, adding any greenery as they build these buildings?
Yeah, they're currently going through TRC review right now for the redevelopment plan, and so there will be additional landscaping requirements that are going to be addressed through the TRC process.
I see. Okay, thank you very much.
And did I see correctly that the other 2 trees that might be saved actually would end up with less impact on their critical root zone?
Yes,
There was one slide that showed that?
Yes, let me go back.
Yeah. Okay, thank you.
Any further questions for staff? Okay, thank you. The applicant would come forward.
Good afternoon, Chairman Moore, members of the board. My name is Sam Frank. I represent the applicant. With me today are Amanda McLeod, a senior project landscape architect with Bolton and Mink, Rusty Snow, who represents the developer, and Tyrone Garrett with the Wilmington Housing Authority. Let me respond to a couple of the questions that you asked before I delve into my presentation. This design did evolve between the time that we made the initial application at the beginning of April and today. It evolved all for the positive. All of the changes that Ms. McLeod was able to incorporate expanded the amount of critical root zone that could be preserved for each of the trees. And furthermore, we learned since we applied at the beginning of April that in a scenario where we provide less impact on the critical root zone for a specimen tree, meaning both with regard to the area and the distance from the trunk to the closest impact, that no variance is required. And so the 6 trees that are absolutely to be saved on this site are no longer the subject of our request to you. And I apologize for any confusion there. At the time we filed the initial application, we didn't know. And so that's why we included them. The request today is permission to remove 3 specimen trees. You asked the question, why are we talking about potentially saving trees that we're asking also to remove? We want to save them if we can. The critical root zones for trees identified as number 7 and critical root zone for tree identified as 1599 will be larger in size. They'll be impacted less with our design than they currently are. However, they are located very close to buildings. And we don't know yet, from an engineering standpoint, whether the grading necessary for the buildings will disrupt the viability of those trees. They're pretty trees. We want to hold on to them. We recognize today that we don't know enough about the final design to be able to make a commitment to save them. In fairness, the applicant does not want to go through this process twice. And so they're asking for your consent today with regard to those trees. So fundamental request, asking for permission to remove 3 specimen trees. The property currently includes an existing affordable housing development. It's in significant need of attention and redevelopment. It's underutilized today, and the buildings are aging substantially. There are 9 specimen trees on that site. There's almost no other vegetation on that site as it sits today. Yeah, here we go. All right, satellite image as the tree sits, as the site sits today. The plan for redevelopment between Houston Moore in collaboration with the Wilmington Housing Authority contemplates replacement of buildings in a different location than where they sit now. That affords much greater opportunity to incorporate green into the site than we have today. As you can see, the large darker green trees that are shown are the existing specimen trees. The 2 that are the variables that are shown on the plan and that we're asking to remove are in the center between building 1 and 2 at the top and at the base of the downward leg of building number 1. This proposed redevelopment would breathe new life into the community, would allow for a significant improvement to and expansion of much needed affordable housing. The applicant is ready and willing to proceed with the project and has just recently obtained and secured critical state and funding necessary to make it possible. Another step necessary to make it possible is your consent today to remove those 3 specimen trees. Here's the tree survey for the site. Those numbers and words are not entirely easy to read. I'm going to get to an image in a minute that will show more clearly where the specimen trees are located and the impact on their critical root zones. But the trees that are depicted as yellow stars on this image are the ones that are the specimen trees. As noted earlier, none of those 9 specimen trees exist today with a protected critical root zone that would comply with the current code. So not only was the development built long before we had a code designed to protect specimen trees, but the trees were much smaller at that time, and they've grown since. So as they sit today, each of those 9 trees has a significantly impacted critical root zone. This is the site plan, again, for the proposed redevelopment. It depicts the location of the 2 new buildings and the other improvements on the property. What you see in the colors there, the orange color shows you the impact of the critical root zone on each of those specimen trees as it's built today. And the blue hatch shows you the proposed development's impact on the critical root zones of the trees. There are also, maybe it comes on a later image. I'll show you in a minute an image that also shows you the distance between the impact of the closest impact and the trunk of the tree. These are some of the live oaks that we are able to save on the site based on the revised design. As you can see, it's a little bit unusual. You've got some very mature, very significant trees without other landscaping in the vicinity of buildings that are decades old and a pretty intricate network of sidewalks. Also images of the trees that can be saved and will be saved. Revisiting the image that shows the proposed impacts This has the dimension between the trunk and the closest impact. It's probably difficult to read as it sits here. Forgive me, I forgot. Can I please ask that this presentation be introduced into evidence? And do you need a hard copy of it?
We do not.
Okay. I have hard copies of the image that's on the screen now, sufficient to share in 11 by 17. If anyone would like that in front of you, please don't hesitate to ask. These are the two trees we hope to save if we can. I really appreciate this image because it demonstrates to you just how close the existing improvements are to those trees. Remarkable that they have survived in that condition as long as they have. Again, these are nice trees. They will enhance the development if it's at all possible to save them. They are also very, very close in terms of proximity to the future buildings, and therefore, with uncertainty about our ability to save them, we ask you for our permission to remove them. With that said, I'd like to introduce Amanda McLeod to talk to you a little bit more about why. How did we design this? Why did we design it this way? Evolution of the design and the like. Amanda is, again, a senior landscape architect with a reputable company here in town and much more familiar with the nuances of the detail of the design. I encourage you to ask her questions about that to the extent you have them.
Good afternoon. My name is Amanda McLeod. Like Sam mentioned, I work for Bolton & Menk. We're a landscape architecture and civil engineering firm here in town. I've been a landscape...
Could you state the address also, please?
Absolutely. My apologies. 1502 Castle Street.
Thank you.
I've been a landscape architect here in town for about 12 years and also the project manager for this project. So like Sam mentioned, I'm going to get into a little bit more specifics about the design and the process that we've taken to get here, working diligently to save as many of these amazing trees as we can. This aerial image, again, depicts the existing conditions on the site. There's 18 two-story buildings out there that serve residential uses. There's one community building in the southeast corner of the parcel. Again, these buildings have been there for a long time. They were built in 1952, so they're 73 years old this year. As you might imagine, they were built with different building standards and different building quality back in that time. So 73 years later, they're in extreme state of deterioration and excessive need of repair, but basically demolition and redevelopment is the best course of action at this time. There's currently 150 units accommodated on site there. If we're able to proceed with our site plan as proposed, there's 200 units proposed in the first phase of the redevelopment plan. And so that is an additional 50 affordable housing units that would be above and beyond the existing 150 units. Circling back to this graphic, because I think it really starts to tell a significant story here about these trees. Like Sam mentioned, these trees do not meet current code as they exist on the site today. With 12 buildings on site in the phase 1 boundary, there's parking, sidewalks, steps, utilities associated with each one of those 12 buildings. And so looking at how we're approaching the redevelopment, we've consolidated into 2 buildings, which then allows us to consolidate the improvements into the areas without the trees. So again, the orange areas depict all of the encroachments or the impacts to the critical root zones of those trees as they stand today. So that might include some of those steps, parking areas, sidewalks, utilities underneath the trees, any number of items. The blue areas depict what we can envision to be our future encroachments based on this proposed site plan. And I'll get into some of the statistics briefly next, but in all cases, with the exception of tree number 5, which is the entirely blue tree there, we have significantly reduced the amount of impacts to the critical root zone. The distances of existing impacts to the closest existing impact within the root zone are anywhere from 6 inches to 13 feet. So that's as close as things can get to the tree in the existing conditions. Our proposed impacts, the closest impact is 12 feet. So we've doubled the distance from the trunk to the proposed impact in all cases, except for tree number 5. Also, by area, we've significantly reduced the critical root zone impacts. Current impacts accommodate 53% of the critical root zone, and our site plan proposes only 17% of impacts to the critical root zone. So that's a lot of numbers, but I think the graphic does a pretty good job explaining that. This is extremely difficult to read, but it's all the math, showing our math behind the numbers and the design. And then lastly, to just speak a little bit more about the progression of the site planning that we've done from the time of being brought onto this project with the Housing Authority. The trees, without a doubt, drive this entire process and this entire site plan. From the beginning, we've engaged discussion with city staff, also arborists, both hired privately, and then we also met the city arborist out on site to discuss the trees, their health, their condition, and if they would survive if we do try to save these. The answer is yes. They're live oaks and they're pretty hardy. So the trees, though they are a significant challenge to work around, they're not the only challenge that we have on this site, so we do have to consider all of these things when we're designing. So in the southeast corner of the site, we will be preserving 6 buildings during the time of construction. So that is something that we need to, keep in mind while we're designing. We also have a utility easement running east to west through the site, just below 3 of those specimen trees. Grading, we all know Wilmington's fairly flat, but there is actually an 11-foot grade difference transitioning from South 13th Street on the western side of the site to South 15th on the eastern portion of the site, which doesn't seem like a lot, but when you have to consider tying in grades at all property corners and boundaries, that's a significant impact to design efforts. And we also are not allowed to grade within the critical root zone of the trees, so that also impacts the ability to work around grading. So to answer the question earlier, we are working very hard to figure out those questions about those 2 trees, but we are very early on in the permitting process. The answer is the City of Wilmington, CFPUA, NCDEQ, all of these entities still have to weigh in on the plan, and so there may be some things that come up that we cannot foresee at this time. Lastly, just to talk about some of the site design, we've really done everything we can to incorporate these trees into the design. We've altered the traffic patterns to move the driveway on South 13 south to give tree number 7 a little bit more breathing room. Open spaces are all designed around the trees. We've pushed the buildings to the periphery so that we can really focus the design efforts on the interior. Additionally, the architects have worked to notch out the building corners at building 1 and 2 end caps, where we're focusing on that tree number 1599. That's one of the biggest questions that we have, but we're really trying to make that a showpiece for a community open space and for the future residents. And again, grading, I've already mentioned that. We're working around that. We're providing permeable paving and infiltration on the site so that we do not have to take up space with a pond, which would further impact our trees. Lastly, landscape will of course be improved and will meet all city codes per the current UDO. So again, to reiterate, we've gone through an extensively long process with this, but it's something I couldn't be more proud of. On the left side, you can see the original site plan that we submitted. We've always been trying to save the trees, but it's how can we do it in a manner that is going to make the trees thrive and do better than the conditions that they exist in now. So though designing around these trees pose significant challenges, it ultimately results in a better design for both the community and the residents. We have worked diligently to work around these trees, and we hope you'll consider our request today.
Thank you. Any questions? Thank you.
If I may speak briefly about the critical 4 factors that are the basis of your decision. First, unnecessary hardship would result from the strict application of this chapter. As we've described, this is a site that doesn't comply with the code today. It is really unusual to have 9 large mature specimen trees on a high-density urban site such as this. Amanda and her team have done an exceptional job of designing around those trees and finding a way to protect them as much as possible. But the reality is, the hardship that would be incurred here without relief from you is that practically the site could not effectively be redeveloped. The hardship results from conditions that are peculiar to the property. Again, the location of these trees on this type of site is highly unusual. It's a fantastic problem to have. As you can see by the rendered site plan for the vision for the future development, this is going to take a site that does not have nearly enough green on it and has some outdated buildings and turn it into a site that's got more affordable homes and substantially more green space than it does today. It is not difficult to advocate that that is a better end result than the condition as it exists today. Hardship certainly does not result from the actions of the applicant. You know, I suppose that those trees could have been taken down somewhere along the way in the name of maintenance. Nobody did that. Nobody should have done that. But it's certainly not the applicant's fault that they continue to exist today. We're grateful for the fact that they continue to exist today, did not plant them, and did not, and therefore did not create the hardship. The requested variance is consistent with the spirit, purpose, and intent of the ordinance. Really, just no question. The spirit and intent of the ordinance is to encourage positive redevelopment, encourage infill where possible, encourage affordable housing, and encourage the preservation of and the planting of treescape and tree canopy. It's one of the easiest arguments I've ever made to tell you that this proposed redevelopment accomplishes all of those things. I have a few images here just to show you again the layout and the intent of the design. Variance factors, which we've already discussed, and I breezed through pretty quickly. If you have any questions for me about our arguments on that, please don't hesitate to ask. And I leave you with an image of the proposed redevelopment as the baseline for why we're here. I encourage you to ask questions that you may have of me as legal counsel, Amanda as the designer, or the developer, or the representative of the Wilmington Housing Authority who's here with us today. Thank you so much.
I have a quick question. There's a significant number of internal and street trees proposed. I mean, I think it's fantastic. Do the proposed trees meet the mitigation requirement for the 3 trees that are going to be removed?
I'm going to let Amanda answer your question.
As I say, I see an expert coming forward.
Those do not meet the mitigation requirements. It is going to be an extreme challenge to plant the mitigation on site. In that case, that's typically handled with a fee in lieu. We haven't gotten to this point yet, but I think staff has entertained planting mitigation trees on other sites. So those trees merely represent the next layer of landscape requirements like parking lot trees.
Gotcha. Thank you.
Mr. Chairman, as you can see, it's about maximized. There's not a whole lot more to be done there. This is beyond the purview of this board, but there is some provision for some relief in the code with regard to mitigation requirements when you provide workforce or affordable housing. That does not extend to our obligation to come to you to ask permission to remove specimen trees out.
Thank you.
If I may, I don't want to get too far ahead of my skis, but in terms of the mitigation and then the phase 2, I know we're not talking about that. Could there be some relationship between mitigation and what happens in phase 2, or is that irrelevant?
I'm going to have Rusty come up. He's with the development team.
Thank you.
This is Rusty Snow with Houston Moore.
Thank you, sir.
Hi, thank you. Rusty Snow, do you need my address?
Please, for the record.
2228 Mac Bayou Road, Santa Rosa Beach, Florida, 34592. As far as the second phase is concerned, I mean, we are looking at doing that as a 5-story tower of senior housing, senior affordable housing. I just don't know if we've got the space to do any more mitigation. I mean, we're certainly open to exploring it. but to kind of meet the goals of the redevelopment, which was to get to that 250 units and add another 100 units of affordable housing for the city of Wilmington, we just are a little limited by space.
So please note also that by developing in phases, this approach affords the opportunity to preserve some housing during construction. And so this is a place where several citizens depend on housing. And by structuring it this way in phases, we allow what will be phase 2 to be available for an additional period of time of occupancy than would be realistic if the thing were developed in an entire one phase.
Thank you. Any further questions? Okay, thank you.
Yes, sir. We're nearby. Should anything arise during your deliberations, please don't hesitate to call on us. Thank you.
Thank you. I'd like to open up the evidentiary hearing. We'll now, if anyone has here provide competent material and substantive evidence in this matter, please come forward. We'll close the evidentiary hearing and open for board deliberations.
I was not aware, but that is interesting that the question of mitigation is to some extent itself mitigated by the fact that this may be low-income housing kind of project. That's helpful to hear, and I appreciate the fact that they're putting in so many new trees.
And I do, and I appreciate the city and the developer working together to amend the proposed development like they have. I think it saves the maximum number of trees, and I think their landscaping is about as intense on the parcel as it can get. Catherine, will there be additional mitigation requirements as far as monetary mitigation requirements?
That's something that would be worked out as part of the technical review process.
Okay, thank you.
I did have a question. Because this is workforce housing, there would be something waived, mitigation or fees was for taking some of these trees out. Was that correct?
I did, and now I'm ahead of my skis.
Okay.
That concept is addressed in the code. I know that to be accurate and have testified to that to you, but I don't know the details. As Ms. Thurston described, that's something we'll have to get into as we go through the TRC process, and I'm sorry I can't provide more information than I have regarding the details of how that works.
Thank you.
So I guess my concern would be if we take trees out, they designate this as workforce housing, then they're not required to potentially do any mitigation, it sounds like. Is that?
Well, I mean,
Okay.
that'd be a TRC decision there, I think, so.
My reference is with regard to the amount of the fee,
Okay.
not with regard to the obligation to replace and mitigate with additional trees.
Okay.
But our plan speaks for itself. I mean, the depiction of what we are showing to maximize as much of that open space with new green as we can is not just commitment, but also the philosophy of the design.
You know, I think a lot of work went into this plan on the city's part and the developer's part. And we've got one tree that we know is going to be removed, which is tree number 5. And then we've got 2 trees, number 1599 and number 7, they're going to try to save, but don't know based on grading requirements and everything and how hardy the trees are. I do think that the applicant has met the 4 findings of fact based on the project, and I think it is necessary in Wilmington to get some workforce and affordable housing, and this project certainly needs some upgrading.
I agree with that.
I think the only concern I have is that they're putting in so many trees as they grow, they're going to be impinging on each other unless they pick species that don't spread, which I'm assuming is the direction they're going to go. that's not really part of what we're here for today. Just a,
Yes. We have an expert.
Do you mind if I address that?
No, please.
absolutely.
Okay.
Curious about the species, yeah.
Yeah, so the trees that we're showing are based on city code requirements, and we will continue to work with the city through the TRC process to make sure that we are meeting code. As I mentioned, I've been practicing here for 12 years, and myself, along with my team, are very well versed in plant material and plant species. We know not to plant live oaks under power lines like the one in the picture.
Like the one.
And we do our very best to plant and specify the appropriate size and species for the right place and
Sure.
location. So
Thank you.
we will do our very best. Obviously, nature does what it does, but, yeah,
Thank you.
thank you.
Thank you. Any further discussion? Do we have a motion?
Move to approve the variance?
We have a motion to approve the variance based on the 4 findings of fact. Do we have a second? All in favor?
Aye.
Opposed? Motion passes unanimously. Are there any further items before the Board of Adjustment today? If not, we stand adjourned. Oh, I'm
I
sorry.
would like to introduce our new member,
Oh, we do have a
Mr.
new
Bill
guy,
Day.
yeah.
I know that you all met him prior to the meeting, but he got his training on Board of Adjustment procedures yesterday, and we're very excited to have him on board.
Well, I informed him that the new guy's supposed to bring snacks, and he did not bring snacks, so.
Next
Wait,
month.
No, wait a minute.
Next month's agenda.
You told me drinks.
Next month's agenda will have 7 or 8 items on it, so we will bring snacks.
Awesome. We stand adjourned. Thank you.